That was the Fraser Committee in 1985. Took a pretty harm-based, progressive view on prostitution. Their recommendations were not the status quo by any means. And so what happened next, I suppose, is a reference to the Supreme Court in 1990, 5 years later. However, in this case, despite interesting commentary, the status quo remained. So, in the majority decision, they decided that communicating in a public place for the purposes of engaging in prostitution does infringe on the freedom of expression under Section 2B of the Charter. However, it is justified in Section 1 as reasonable limitation. So it's, anyway, there's reasons for this that we'll get to in a second. The sanctions against bawdy houses do not violate Section 7 of the Charter. They are not vague given the definitions contained in the case law and the code. And we saw this before in Section 43 dealing with the limitations, or I guess the allowing parents to use some degree of reasonable physical force with their children. So the sanctions against bawdy houses are limited by the case law and thus they're not too vague to be unconstitutional according to Section 7 of the Charter. Dixon goes on to say the status quo is fine. The question is, by indirectly making prostitution illegal through the direct criminalization of communication, has Parliament offended the principles of justice? So rather than just making prostitution illegal, they make all these other activities illegal. And does that offend the principles of fundamental justice? No, it does not. Parliament does not need to refrain from using criminal sanctions to express society's approbation of street solicitation. The principles of fundamental justice are not designed to ensure optimal legislation. The legislation as it stands does not violate principles of fundamental justice. And here we kind of see the narrow or perhaps true role of the Supreme Court, which is simply to decide if it is constitutional. It's up to the legislators to create optimal legislation if the public doesn't like the legislation. But as it stands, it's not unconstitutional. So says Dixon. Lemaire, the objective of the legislation is to prevent the nuisance of traffic congestion. And I believe that this is why, or this and the other reasons I'm about to cite are the reasons why, who's the first judge? Why the majority decided it was justified under Section 1. So it's equally important to minimize the public's exposure to an activity that is degrading to women. It's equally important to minimize the possibility of young people entering the trade. And for those reasons, it's just the law against communicating for the purpose of prostitution is justified under Section 1 of the Charter. So the appellants here argued that Section 7 of the Charter allows them to carry on a lawful activity, so right to liberty, I believe, Section 7, along with other things, and they said no. So dissenting was Wilson, and she makes the distinction here that it's right here. So she makes the distinction of the fact that prostitution is not a crime, must be recognized in any Section 7 analysis, regardless of one's personal moral views. So the fact that it's not a crime is actually a really important point, according to Justice Wilson. I'll come back to the first point now. She suggests that the public place, communication in the public place, is too broad and it prohibits communication which may take place in very secluded areas. It enables the police to arrest citizens who were disturbing no one because they were engaged in communication concerning something that is not prohibited by law or by the code. in any manner communicates, and in any manner is from the code, equals any form of human communication. So a person who looks like they are a prostitute, who is hailing a cab, for example, could be harassed by the police or could be questioned by the police, which is perhaps someone considered not a big deal if we're trying to reduce the harms of prostitution, but for that individual would be not a very enjoyable experience, to put it lightly. When a defense is provided for a criminal code is because the disapprobation of society is not warranted. This is equally true of an activity that is not criminalized. So, and there are many immoral acts which are not criminalized. Sorry, there are many more immoral acts which are criminalized, but there does seem to be a reluctance to criminalize prostitution. And she suggests that this is because the real victim of prostitution is often the prostitute. It's a transaction that normally occurs in private between consenting adults, and it's a very old trade, clearly meeting the social need. So these might be influencing the decision to not actually criminalize it. And it's not criminalized, so that's an important distinction. Parliament has chosen to regulate certain instances of prostitution by means of criminal laws to deprive people of their physical liberty. And this triggers the Section 7 charter application. So, yeah, Justice Wilson takes issue with the fact that they are indirectly creating sanctions against prostitution by creating all of these infringements on people's physical liberties so that they don't do something which is not actually illegal. Anyway, she was the dissent, she was not the majority. The status quo was maintained. In the same year, we had other common law case dealing with prostitution. R versus Skinner. The Supreme Court of Canada heard it and found that prohibiting communication in a public place for the purpose of engaging in prostitution did not violate freedom of association under 2D of the Charter. And Wilson, again dissenting, presumably says the court should avoid the temptation to make a moral judgment in deciding whether or not associational activity is protected by Section 2D. So here again advocating for a more strict, harm-based and objective test for determining whether something is protected or not by the Charter. And also seemingly suggesting that their moral judgment is subjective, anecdotal, and unuseful. R versus Downey, 1992, 2 years later, Justice Corey says, when a person lives with or is habitually in the company of prostitutes, the burden of proof shifts to the person. They must prove that they do not live on the avails of prostitution. And of course, this is against the innocent until proven guilty part of criminal law, but they justify it as a Section 1 limitation to protect prostitutes as a particularly vulnerable segment of society. And here, this appears to be strengthening the status quo and strengthening the, I suppose, a more conservative approach to restricting prostitution. Moving all the way to 2006, 14 years later, and the Standing Committee on Justice and Human Rights interviewed or heard statements from many different groups and people and drafted a document stating the negative impacts of criminalizing prostitution and the positive impacts of criminalizing prostitution. So, they state that criminalization is intended to control prostitution-related activities in Canada And that jeopardizes the safety of prostitutes as well as access to health and social services. So Section 213, this is communicating in public in order to engage in prostitution. It accounts for 90% of the prostitution-related offenses, but they state that it's not having the desired effect of changing prostitution behavior, or I guess decreasing the amount of prostitution. It is actually changing prostitution behavior, but what it's doing is causing them to act in secret or isolation. So they have the choice between acting in public and feeling more sense of security, having the police around who protect everyone else from people who want to be violent, or acting in secrecy and isolation and being protected from the police who want to arrest them in this case. So by acting in isolation, the risk of abuse and of violence is very high. In British Columbia, between 75 and 84, 80% of the women murdered were street prostitutes. And isolation also minimizes information sharing between prostitutes and also between prostitutes and social services, healthcare workers. Sticking with Section 213, it causes frequent changes of location due to policing and court orders, and this separates them from their friends, co-workers, regular customers, and familiar places, further endangering them. And also, because they're not allowed to communicate in public, it's difficult to screen clients. So extensive chatting about what the acts are and how much it's going to cost are likely to get you arrested. So it puts people who engage in prostitution in a very difficult bargaining situation because they're forced to finish the negotiation quickly and get in the car, at which point it's difficult to negotiate. Section 210 prohibits body houses. As the law is now, with the restriction on body houses, it's only possible to carry out sex work by going to the home of a client or to a public area. So Section 210 also encourages landlords to rescind the lease of anyone suspected of committing acts of prostitution. Section 212 prohibits living off the avails of prostitution of another and procuring a person to engage in prostitution. And this we saw in the Downey case, I believe, 1992. The burden of proof in this section is shifted to the person who is frequently in the house of a person who's acting as a prostitute. However, prostitutes don't always live with people who are exploiting them. There are some cases where they're living with other prostitutes, or they have a mutually beneficial relationship with a person they trust, and they're living in a cohabitation situation that reduces the risk of abuse and allows them to save money. So some people who engage in prostitution would prefer an employer-employee relationship, and this restricts that ability. The other effects are of these three pieces of the criminal code are that people engaged in prostitution live in fear of being arrested, losing custody of their children, losing lawful employment that they might have, and being stigmatized for being a prostitute for their whole life. The stigma is also an issue, and for that reason they tend to avoid reporting violence committed against them because they would prefer not to be outed as a prostitute in some situations, and in that sense they're deprived of police protection. And lastly, the stigma associated with prostitution in some cases reinforces the characterization of sex workers as less valuable humans, which might in some way make them acceptable targets for abuse in the minds of some. So the positive effects of criminalization is, anyway, I guess the philosophy behind advocating for criminalization is that prostitution is inherently violent. So I'm just going to read this out. It isn't alienating activity that makes up part of the oppression, or it is an alienating activity that makes up part of the oppression of women by men and reinforces an unequal relationship between the sexes. They believe that Parliament's responsibility is to censure the act of prostitution by criminalizing men who buy sexual services, as well as those who live on the avails of prostitution of another person. They also believe that Parliament should support all women who are engaged in prostitution and were, of consequence, women who are engaged in prostitution and who consequently are sexually exploited, and the ultimate aim is to end prostitution. So Section 213, police officers agree that it doesn't lead to a reduction of the incidence of street prostitution. However, they do see it as a social intervention in a sense. By arresting a person who's engaged in prostitution, they can protect them from a drug habit or from the inherent dangers of prostitution. There's also cases where once they're arrested, they may have to meet with a counselor as part of their probation order. And if Johns are arrested for communicating, then they may have to take part in a John school where the damages and exploitive nature of some prostitution activities are illuminated. But all agree that the most marginalized individuals are the ones most likely to experience the consequences of criminalization. So the people engaged in prostitution are presumably marginalized, and they are the ones who are most likely to be sanctioned. So that's what we did this week. Looked at indecency and started to look at the development of prostitution laws in Canada, and we'll continue looking at prostitution next week.